Excellencies, ladies and gentlemen, dear guests, dear colleagues, my name is László Kontler. I am the Pro-Rector of Central European University for Budapest, and I'd like to cordially welcome you all at this August event. As you know, this is a university which no longer has educational programs in this city because Hungarian legislation has made it impossible. So the degree programs and the students, unfortunately, are mostly residing in Vienna. So you might ask why CEU needs still a pro-rector for Budapest, and what is it still doing in Budapest after the unfortunate developments that have afflicted us a couple of years ago? The answer to this question is an incredible range of things, all the things basically which this university has been pursuing in Budapest unharmed for 25 years, and which are not confined to the most central tasks of a university, that is training students and issuing diplomas. But CEU has been many more things than an industrial enterprise producing diplomas. CEU has been a cultural, intellectual, and civic program with many activities beyond teaching degree students. And we still continue that. I always say we do everything that the law still permits us to do, and which we have been doing, and I think we have been good at doing for nearly 3 decades in this city. We do a great deal of outreach on the cultural, educational, and civil front. Particularly important are the non-degree educational programs that target disadvantaged and vulnerable groups. We call this emergency education. Groups that have been afflicted by war, that are exposed to social marginalization, or suffer from other types of adversity. We do a great deal of cultural and civil outreach. We shelter like-minded, like-thinking, and like-fated colleagues and institutions that have been suffering from the Hungarian government's educational policies, like the RUMP, the Free and Independent Remains of the University of Film and Theatre. But we give offices to publishers, non-governmental organizations, and so forth. Most important of all, we continue to do cutting-edge, world-class research in our flagship institutions. We have at least 3 of those. The oldest is, as you know, the Open Society Archive, which is not merely a state-of-the-art center for documentation on Cold War, contemporary and recent history in general, genocide, war, violence, and related subjects, but an institution which has its own research programs and hosts research fellows on its own. We still have the Institute for Advanced Study, the heir of the one-time Collegium Budapest Institute for Advanced Study, which runs fellowship programs for scholars from all around the world. And last but not least, we have the Democracy Institute, which has been founded quite recently in the turmoil of the transformations of the late 2010s, that is after the forced relocation to Vienna. The DI has 5 working groups. It pursues research in various subject matters relating to the problems and challenges to democracy in the 21st century on local, regional, and global levels. It has partnerships and networks throughout the globe. It benefits from the traditions of CEU in this regard. One of the most recent initiatives that we are celebrating today is the launching of the Rule of Law Clinic. There are people in this room who are much more qualified than I am to talk to you about that. So here I'd like to thank only for the tremendous efforts that my colleagues in the Rule of Law Research Group of the DI have been making under the leadership of Dmitry Kochenov. And also would like to welcome back to CEU our alumnus Adam Bodnar in his new functions as well, but he'll be introduced by my colleagues from the Democracy Institute. Thank you very much.
Ladies and gentlemen, my name is Barbara Grabowska-Moros and I'm a head of a Rule of Law clinic. It's a 3-year project funded by Dmitry Kochenov with a generous grant from Mercator Stiftung. It aims to give a voice to a fundamental value of rule of law before the highest courts and with cooperation with international organizations. Next to bringing third-party interventions, we aim to play an important role in providing a direct assistance to practitioners and scholars. Clinic offers support to rule of law professionals and facilitates fellowships to enhance expertise in processing rule of law issues. We would like to show that the rule of law is a truly practical concept and that scholars have a role to play to make it true. Our today's keynote speaker's professional path has fully proved that scholars could and should be engaged in defending fundamental values. He is CEU alumnus in LLM program in comparative constitutional law. He is an author of numerous publications in rule of law, human rights, civil society. As Human Rights Commissioner in Poland, he fought for giving rule of law a true meaning when the checks and balances were dissolved and the effective legal remedies were undermined. He received numerous awards for his work and for his commitment. In October 2023, he was elected a senator, receiving more than 600,000 votes. In December last year, he was appointed Minister of Justice in Poland and tasked with a mission to re-establish basic values and rule of law principles, such as guarantees of judicial independence. He has kindly accepted our invitation to give a keynote speech on one of the main topics in his current job. Ladies and gentlemen, Minister Adam Bodnar.
Ladies and gentlemen, dear Mr. Rector, dear directors, dear friends, distinguished audience. It's always nice to be back at CEU in Budapest. For me, Budapest would always be headquarters of CEU. And I'm really happy that I can join this event when the new project starts here at CEU, the Rule of Law Clinic. Congratulations to Dimitri on starting this project. Congratulations to Mercator Stiftung for supporting this great idea. I'm pretty certain that soon we will hear about number of third-party interventions and other strategic cases litigated before ECHR, Court of Justice, or maybe even before some UN bodies. It was really nice to be introduced by Dr. Barbara Grabowska-Moros. You know, it's also, there's one additional symbolism to what we are talking about, because just tomorrow, more or less at this time, we'll know about the judgment of the European Court of Human Rights in the case which is entitled Petra against Poland and Bychawska, Siniarska and others against Poland. And those others are three Polish civil society activists, lawyers, Wojciech Klicki, Katarzyna Szymielewicz, and Barbara Grabowska-Moros. And basically, it is the case which is going to provide for the interpretation whether Polish law and Polish practices sufficiently guarantee protection of the privacy in the context of surveillance. The case has been litigated as a strategic case for a couple of years already. There was a hearing last year. And right now, finally, we'll have a case. And for me, this case is important because maybe I will be one of the ministers responsible for the implementation and for changing the Polish law regarding this. So Barbara, fingers crossed for your success tomorrow. Ladies and gentlemen, I would like to spend this time with you and to explain some of the issues concerning the process of the rule of law recovery and the process of transition back to liberal democracy in Poland. As you know, on 15th October 2023, the coalition of three political groups, Civic Coalition, Poland 2020 / Polish Business Party, as well as the left-wing party, has won elections. Thanks to this victory in elections, the new government has been formed by Prime Minister Donald Tusk. And basically, what was also quite innovative for Poland, so-called coalition agreement, has been signed by all those political parties and political groups, and basically the new government and the new parliamentary majority has moved into the process of making different changes, including those changes that concern rule of law. I'm responsible for this rule of law recovery process because I was appointed as the Minister of Justice. Interestingly, I'm at the same time Prosecutor General of the Republic of Poland. In Poland, those two functions are merged. It was not a case between 2010 and 2016, but then the government by the Law and Justice Party came, and Minister Zbigniew Ziobro, quite a controversial figure in the Polish politics, has moved towards merging those institutions. And in fact, prosecution service has been used throughout all those years as one of the major instruments of power. So basically, I'm saying this because I kind of inherited the function of the Prosecutor General. So on the one hand, I'm responsible for making different things concerning prosecution service, but at the same time, I try to do a reform to demerge, to separate the office of the Minister of Justice and the Prosecutor General. Okay, but I think that before we go into details of what is going on and how this process of the rule of law recovery is going on, we should remember that Polish ruling majority does not have a constitutional majority. Moreover, it does not even have a majority to overturn the veto of the president. So by virtue of the Polish constitution, to overturn the veto, you must have 3/5 majority. And second, we should know that representatives of the previous system of governance are present in a number of institutions. So for example, Constitutional Court is fully controlled by, I would say, people friendly or people that were appointed by the Law and Justice Party. The same with the National Council of Judiciary. Plus, we have a number of new judicial nominees, judges that were appointed or promoted after 2018 to the Supreme Court and to the common courts. So this issue is especially important because more or less we have 2,000 judges that were promoted after 2018 as a result of the recommendation that has been made by the National Council of Judiciary. And this National Council of Judiciary after 2018 served pretty much political purposes. There are a number of judgments decided by the Court of Justice of the EU and the European Court of Human Rights that refer to this issue of so-called original sin that in the context of the promotion to the judicial positions by the politicized body, which is the National Council of Judiciary. We estimate that 50% of people promoted, of judges that are so-called neo-judges, are those who were judges before, but they were just promoted after 2018 to higher judicial levels, higher judicial positions. 30% are just completely new judicial appointees, and more or less 20% are graduates of the National School for Judiciary and the Prosecution Service. We have such a special school based in Kraków, and basically if you are a graduate, you do not have any other option to become a judge than to have a promotion by the National Council of Judiciary. I mention this because you will see later on that it has a huge impact on current discussions that we are having in terms of transition. Moreover, the situation is that on the one hand there is a parliamentary victory, but on the other hand, in this process of transition, we have quite a lot of people that basically claim that they didn't make any, let's say, personal or individual mistake in their previous life. They try to either protect the previous system, or at least they try to protect their individual choice they have made in the context of the judicial promotion. So quite rarely you may find a person who is so-called neo-judge that would say, you know, it was my mistake to participate in the process. So somehow, by presenting different legal arguments and different legal actions, they kind of defend their individual choice that they have made between 2016 2023. So that is more or less like the legal and political background of things that happen in Poland. But as I said, one of the principles of this new government was to move towards rule of law recovery. And you know, there are different legislative plans, but those legislative plans and different other actions have to be adjusted to a very difficult daily political reality. So maybe I would like to give you some of the general principles how this process of transition is going on, and what are like the major points of reference on which we try to make this transition back to the typical liberal democracy. So the first thing, and I think one of the most important, is obviously I would name it reintegration or loyalty to the European Union, which means that we do our best to implement all the judgments of the Court of Justice that were given with respect to Poland, and as well as we change positions in those cases that are pending still before the Court of Justice of the EU. Second, in this early moment of just after taking the power, Poland had EU funds that have been frozen. And they have been frozen because Poland did not implement certain judicial milestones in the EU recovery plan. So there were different non-legislative measures taken in order to unblock this money. Third, I have proposed and I have submitted in Brussels action plan action plan concerning the rule of law recovery in order to get out of the Article 7 of the treaty procedure. And this action plan has been more or less accepted, and Commission last week or 2 weeks ago has submitted a motion to withdraw with respect to Poland Article 7, claiming that there is any longer clear risk of further undermining of the rule of law. And finally, we have made a procedure to join the European Public Prosecution Office. It's interesting because this procedure and its formal level does not require any legislative change. So it is just a declaration by the government, which is later on accepted by the European Commission. But for us, the joining EPPO was like the clear signal that we want to be bound by the operation of the European prosecutor, that we want to have a full control over the use of the EU money, as well as we want to have a support of the European prosecutor in terms of prosecuting transborder VAT abuses. So EU and this, let's say, reintegration, showing loyalty, cooperation, contact, professional contacts with EU Commission, with the DG Justice, with other commissioners, was extremely important for us in this first moment. But the second point is not that we know that this whole discussion regarding rule of law is not about EU and the relationship with the member states, but there are also a number of things happening with respect to other international organizations. So one of the steps that have been taken was my visit to Venice. I've participated in the meeting of the Venice Commission, and basically we actively cooperate with the Venice Commission on making opinions concerning different laws that are proposed. But when it comes to the European Court of Human Rights, also we have a lot of cases that have to be implemented, including pilot judgment in case of Lech Wałęsa against Poland, the case that is a little bit like that is symbolizing number of different abuses. So once again, here the position of the government is that we are not, let's say, arguing, we are not questioning the position of the European Court of Human Rights in the rule of law cases. We claim that the ECHR is right, and the role of the government is basically to implement those cases. Then I would like to come to the legislative process. It's, I would say, the most tricky issue. Because when it comes to the legislative process, even if we start a process, even if certain draft laws are prepared, even if they go through the parliament, we do not have a guarantee of success because President of Poland is claiming that he's not going to sign any laws that would especially question the validity of judicial nominations that he did after 2018. So the big question is, are we going and making any compromises regarding this issue with Mr. President? But even if those compromises are made, we do not have a guarantee that at the end of the day, President would sign those laws. Or we have to wait until the middle of 2025 when the term of Mr. President ends. President Duda. But still, there is no guarantee that after the middle of 2025 we would have a president that is in favor of those judicial reviews, of those judicial independence legislation drafts. But still, we see that there is a need to adopt a number of different laws that affect, I said already, the independence of the Prosecutor General Office from the Ministry of Justice. It is the law about the reform of the Supreme Court. We need to have a law about statutes of those new judges, those judges that were appointed after 2018. And the question is what kind of approach to adopt and how to verify or analyze these statutes. We need a new law on the organization of common courts, and to bring back something like judicial self-governance and proper method of appointment of disciplinary judges, or to reform in general the system of disciplinary responsibility for judges. And finally, we need to have a law about the National Council of Judiciary. So all those laws, and I forgot about one more thing, we need to have a new law about the Polish Constitutional Code, and maybe possibly the change in the constitution regarding the operation of the Constitutional Code. So as you see, it's quite massive task to adopt all those laws. And right now we are at the stage that we are either preparing those laws or we are consulting some of them, but the general idea is to be kind of prepared to either try to pass those laws that are somehow possible to be adopted and not vetoed by the president. And with respect to other laws, to prepare them in a very comprehensive way with the wide participation of scholars, civil society, and all different stakeholders, and maybe to wait until the half of 2025 when there is going to be a president that is not questioning some of those judicial solutions. My role is that I'm responsible for coordination of this effort, also for those, let's say, political choices. But I also try to steer this process in such a way as to make it legitimate as possible. So, for example, one of my initiatives was to create or to reappoint so-called codification committees. So we have right now 3 codification committees. One is codification committee on the judicial reform on prosecution service. There is also codification committee on civil law and codification committee on penal law. So those 2 latter ones were existing in Poland always, but they have been simply cancelled for the period 2016-2023. So right now my role is to reestablish them. But basically their role is also to kind of give the idea that the word of experts world of scholars is cooperating with the ministry, that they are giving support to some of those measures. But there are also some non-legislative measures that are implemented on a daily basis. Among some of those non-legislative measures, we have created a practice of appointment of so-called disciplinary ad hoc judges. So these are like people that could be appointed by the Minister of Justice individually, and they have a role of, they can intervene or they can take over some of the cases that are made by other disciplinary judges. And we had plenty of cases concerning Polish judges that were targeted for the use of the EU law or for making preliminary references. So what I do is that I appoint some of those ad hoc disciplinary judges in order kind of, to stop proceedings that are detrimental from the point of view of proper application of the EU law or that simply serve the purpose of targeting some other judges. Please note that I do not have an ability, because of the existing legislation, of just dismissing existing disciplinary judges, because I would say their terms were guaranteed in quite a strong fashion in the existing legislation, and without change of the legislation it is impossible to do anything with them. So basically you must find a method how to, let's say, limit their negative activity. When it comes to some of those principles concerning transition, one of the big changes we did is transparency of any appointments to key judicial or prosecutorial positions. So in any case, we organize open competitions that are transparent. Some of them were even video live streamed. And interestingly, right now, we have a competition for the judge of the European Court of Human Rights. In fact, this competition is organized by the Ministry of Foreign Affairs, but we have 25 candidates, and if you look into the list of candidates, you see that somehow lawyers regained the trust into the system, because you see people that are really high-level professionals that are applying to become those judges, and if you have 25 candidates, it shows that you have a real possibility of choosing good guys. There was also a competition for the position of the European prosecutor or for the position of the head of the National School for Judiciary and Prosecution Studies. So for me, this, let's say, transparency and open way of appointments is a little bit like a sign that to the society that, these are things that you can do differently than the previous government. That it is not about arbitrary power, it is about giving voice to the society and to make things in transparent and open way. And finally, I would like to underline that sometimes we have this moment that we are lacking like a clear standard. Because, if we have the constitutional code that is in crisis, we have the constitutional code that was politically instrumentalized for last 8 years, there is a question, okay, so what is like the point of reference for you in interpreting the Constitution? So in this regard, we try to take advantage of ECHR jurisprudence, Court of Justice jurisprudence, as well as Venice Commission recommendations. And I think the good example of this approach is the practice of appointing court presidents. By virtue of the legislation, in case of dismissal or in case of resignation of any court president, it is the Minister of Justice that is appointing the new one. Okay, so basically, by virtue of the legislation, if I have a vacant position, I can just, look into, let's say, portfolio of some of the judges in adjudicating in a given court and say, okay, you will be the one. Okay, but I have decided to limit my all power, and basically I have decided that in such a situation I would always send a letter to a given court saying that, listen, there is a vacant position, please give me 2-3 candidates for this position. So please assemble yourself as a kind of, as all the judges in a given court and select the best candidates in your opinion to this position. And out of those 2-3 candidates, I will select the one. And this practice works pretty nicely, and it is practice which is based on the Venice Commission general recommendation. And up to now, I have managed to appoint, using this procedure, 42 new court presidents. And the consequence of this is that you may feel like a completely fresh air in the courts, that courts that were subject of such a huge pressure in the previous era, right now they have a right of to make a decision making, and that the Minister of Justice is building some kind of a trust concerning them. I would say that when we go deeper and deeper into this process of transition, we see we observe a lot of different problems. I've mentioned already about some of them, that in case of Mr. President blocking some of the solutions, you do not have like the clear avenue of making changes. But maybe let me give you some of the indications of some of those, let's say, specific issues concerning transition. So I would say that one of the first questions is what is the limit of the compromise you can make in this difficult moment? So right now there is like dispute going on between, to be honest, myself and some of the Polish judges or judicial associations concerning the new law on the National Council of Judiciary. To put it shortly, Polish law provides that 15 judicial members of the National Council of Judiciary are appointed by the Parliament. We are going to change it and bring it back to the previous solution that existed before 2018, that all those judicial members are elected by peers, not by Parliament, but by peers. Because if they are elected by Parliament, it makes a political institution out of the National Council of Judiciary. And then the question is, who should be a candidate in those elections? So in my original proposal, I provided that this should be only judges that are, let's say, without any problem with their appointment, so judges that were not appointed by the National Council of Judiciary, created after 2018. So all those judges without this, let's say, sin of having any professional recognition by this National Council of Judiciary between 2018 and 2023. Then it appeared that Venice Commission said that if you exclude 2,000 judges out of 9,000 in such a way, it is not proportional, you should find some other measure. So, so basically this new measure, which was adopted in the Senate, so in the reading of the law in the Senate, provides that there is no any limitation, that all the judges, irrespectively by whom they have been appointed, could be elected to the new National Council of Judiciary. Such approach gives a chance, some minor chance, but maybe there is some chance that Mr. President would not veto this law. And if Mr. President does not veto the law, then it means that we'll have a National Council of Judiciary with some of the, we'll have this National Council of Judiciary in a new composition soon, within a couple of months, so we'll be able to, let's say, come back to the proper operation of this constitutional organ. And it would allow for moving forward with some changes in the judiciary. Judicial associations are claiming that we cannot allow that any new judge is basically appointed to this organ that is going to cure the Polish judiciary. So the conflict is really, I know that it might sound to you quite, maybe later on I will have time to explain more, but it is a little bit like the discussion about the level of compromise. So either you are trying to keep kind of like a clean approach and not agreeing to any, let's say, concessions, or you are trying to find some kind of a compromise in order to move forward quickly with some further deeper reforms of the judiciary. Another problematic issue is that some of those changes that are made in Poland are based on the basis of so-called, not maybe on the basis, but they are supported by parliamentary resolutions. So there were 3 parliamentary resolutions adopted that I would say assessed a state of affairs regarding public media, National Council of Judiciary, and the Constitutional Court. And the question, and of course, any parliamentary resolution cannot have any legally binding value. But then the question is, okay, but if you have that kind of a parliamentary resolution, what kind of advantage can you make out of those resolutions? So to what extent they authorize some organs to to behave in a certain way. So for example, for me, one of those parliamentary resolutions allowed me not to cooperate, to be honest, at all with the Constitutional Court. So I do not use my function as the Prosecutor General to make any submissions to the Constitutional Court in a situation when the operation of this Constitutional Court is assessed by the Parliament that it does not fit any judicial review purposes. It is just an institution that is used for political purposes. It leads me to another problem, which is, okay, the Constitutional Court is still in operation. It is still giving judgments. It is still giving even prior restraints orders. Recently, one of the prior restraints orders by the Constitutional Court concerned the operation of the parliamentary committee to investigate Pegasus spyware affair. So they said that allegedly the resolution of the parliament that is establishing that kind of investigative committee is contrary to the constitution. And they prohibited operation of this investigative committee. So to be honest, nobody serious reacted seriously to this prior restraint. And we have like the growing number of decisions, judgments of the Constitutional Court that are simply misobeyed. And we have a feeling that the Constitutional Court is so much politicized and is so much instrumentalized, is used in so instrumentalized way that it cannot be respected. But still, it is quite sometimes difficult to explain why are you not following some orders of the organ that is having the official stamp of the country and is not doing certain things. And finally, I would say the final problem is one of those, let's say, issues I would like to mention is to what extent you may use some legislative provisions that have been adopted during this illiberal era. And right now you are using some of those provisions, but for a completely different purpose in order to make a rule of law recovery. In my opinion, you should do it because you do not have any other measures, but it may also create a certain level of controversy. So as you see, this process of transition, this institutional transition, is not that easy. But I would like to move forward to another dimension, which is quite difficult to deal with, which is the accountability. Okay, so if you read any book about transition, it's not only about, let's say, reparation, reestablishment of institutions and their reputation, but it is also about accountability for abuses that happened, and in Poland it lasted for 8 years. There are different purposes of accountability: bringing justice. It is recovery of money. If there was a financial abuse, it is about identification of mechanisms of building illiberal power. It is also fulfillment of political promises. So if you promised that you will hold people accountable for abuse, you have to deliver. By virtue of Polish law, you have a couple of available measures of accountability. One is Tribunal of State, which is about this constitutional accountability. Please note that in Poland we never had a really well-working mechanism of constitutional accountability. So using this time Tribunal of State creates a lot of practical and legal problems. There are investigative committees. We have right now 3 investigative committees going on. There is a possibility of criminal accountability, obviously, disciplinary accountability, especially with respect to judges and prosecutors. And we contemplate maybe creation something like at least I have this in my mind, a creation of something like what I would name like the Commission of Truth, in order to investigate some of the specific examples of targeting Polish judges. So there were some examples of very systemic abuse of the position of those independent dissident judges in Poland. But it is rather at this moment rather idea than something specific. But I would like to say that in order to think about accountability, we should also understand that there are different types of, let's say, cases that could be subject of this accountability process. So first of all, different cases of financial abuse, that somebody simply has stolen money and you must find those people accountable. You might have cases where this financial abuse has been connected with some systemic abuse and building power structures and abusing secret services. So the Pegasus spyware is one case. Another case, which is really loud these days, is the case of the abuse of money from so-called Justice Fund. The Justice Fund that has been created to support victims of crime, but has been used in order to implement specific political purposes. Then you might have cases concerning some individual involvement of some people in the process of destroying the democratic state. Like, for example, one of the cases that is in the prosecution service right now is the case concerning hate affair in the justice system. It was the case in which the case concerning Polish judges that created something like the hate campaign against other judges. And they were affiliated around the Ministry of Justice, around the previous Deputy Minister of Justice. So these are, like, I would say, like 3 types of cases: financial abuse, systemic abuse in order to build illiberal state, and some individual abuse in order to achieve some political purposes. But please look that when we are thinking about accountability, that also it means that we must come back to different cases that happened between 2015 2023, and they have been somehow stopped by the Law and Justice Party. So, for example, even today in Polish Weekly, in Newsweek, there is a huge article about one of the major affairs that happened in 2014-2015, and then it has been secretly stopped by the prosecution. So basically you have to come back to those cases, or to cases concerning people participating in demonstrations that were complaining on some physical abuse, and those cases were not litigated later on. And also, process of accountability means that you must review some unjustified prosecution against entrepreneurs, against some political figures, against some people that were civil society activists, number of people that were somehow targeted by the prosecution service, and you must look into those cases. So I look at this like in a very general way, because that's my role a little bit also. Not a little bit, but that's my role to deliver here. So there is an expectation that, being the Prosecutor General, that I would steer the prosecution service in this direction, that this accountability expectation is fulfilled. And right now we have a problem, because on the one hand you have a high level of expectations, so somehow people have a feeling that it is like, you know, in this like world of Avengers, that you are just coming and with one click you are just changing everything. It does not work like this. Because first of all, you must respect rule of law principles in doing accountability. Second, you have limited resources. So you do not have, like in this process of transition, you do not have like immediately 6,000 prosecutors who are just one day becoming Democrats. You know, if they were for 8 years living in a completely different system, and I don't claim that they were, you know, let's say, fulfilling all the expectations of the previous government, but rather they were trained to be disciplined, to be hierarchical, to be obedient. So it is not that easy, like from the day one, to kind of change the whole structure and to change the whole operation of the prosecution service in a way that it works to fulfill, let's say, democratic purposes. Second, all those procedures are time-consuming. So if you want to do it in accordance with the rule of law, you must guarantee, of course, right to defense. You must guarantee a certain level of professionalism in the context of legislative procedures. And finally, you do not have availability of any other measures than those existing ones, because, as I said, you have a limitation regarding legislative possibilities. So I mentioned this problem of accountability because, on the one hand, you may go forward with some institutional reforms. You may go forward with, let's say, with this reestablishment of the European loyalty, with some personal changes in the prosecution service, in the judicial system. But at the same time, if this process is coupled with the accountability and people expect a lot regarding that those accountability processes are going quickly, then the frustration may emerge and people may feel that nothing has changed. Although a lot of things change, in practice they may feel that, okay, you know, this or the other guy, they are still, you know, free, they are still not responsible for anything, and somehow people do not accept a message that yes, but you have to wait some period of time because in the rule of law state you cannot do certain things in a revolutionary way. So it is one of those problems of transition I would say identify on a daily basis. I'm here today with Dominika Ziętara, who is my close advisor on legal and political affairs, and on a daily basis we experience, you know, all those discussions concerning this process of accountability in the context of transition. Ladies and gentlemen, to come to an end, I think that you know, for us this period is interesting because we are once again a kind of a laboratory country. So Poland was one of those laboratory countries in terms of shaping EU policies regarding rule of law compliance. And right now we see that we are facing this laboratory experience regarding transition back to liberal democracy. Second, I think that what is one of the most important aspects is the scale of this transition, that it is not just about changing 1, 2, 3 pieces of legislation, but it is very fundamental regarding, as I said, about institutional level, accountability level, as well as, let's say, review, verification of hundreds, thousands of individual careers. And I think there is no other example in the world of country that would go through that kind of a transition. Please note, sometimes there are discussions comparing the situation in Poland to some Latin American countries that are coming back from illiberal system. But I think that in case of Poland, we do not have the situation that the change of government comes with, at the same time with such a moral condemnation of the previous government. Of course, I can condemn in a number of ways, but it is not the situation as that you can somehow compared to the Marshall state in the beginning of 80s in Poland. Or you cannot compare it so easily to the transition that happened in 1989. The third point is that there are different, in the society, there are different visions of transition. So there is no like one-sided vision how you should do it. Okay, so if you are all those parties that are forming the coalition, they know that we should bring back rule of law, that we should bring back European integration, but you see some differences between, let's say, more revolutionary approach and kind of, you know, step-by-step approach that I present. So I rather try to behave in a way just to use existing possibilities than just to kind of try to promote the vision that you should ignore all the norms and to make everything in a revolutionary way. So, but then the question is how to meet people's expectations if you have that kind of different visions. And there is also another challenge that from the point of view of so-called ordinary citizens, they are quite lost in terms of understanding what is going on with this constitutional court, with judiciary, with National Council of Judiciary. They expect simply speeding up court proceedings. They expect resolution of some systemic problems like the abusive loans and litigation concerning those cases, or operation on a daily basis of family courts. They expect some kind of a stability of the legal system. Entrepreneurs expect safe regulations and also friendly justice system. So your role is not just to make transition, but also to take care about repairing justice system at the same time. And finally, the big question and the big challenge is how to secure the future, how to secure the long-term support for the process of changes, how to rebuild institutions in a sustainable way. So Petra likes sustainable rule of law approach, and how to invest into the civic education as one of those vaccines that may prevent us from coming back to the illiberal order. Ladies and gentlemen, thank you very much for your attention.
ladies and gentlemen, now I would like to introduce our panelist speakers to enter the stage. Professor Petra Bárd, Professor Eva Brems, and Professor Dimitri Kochenov. We will have ability now to discuss Adam's Bodnar lecture in details and also ask him additional questions during the Q&A session that will follow the panel. I hope you can hear me. I mean, I had like 3 questions to Adam Bodnar, but after the lecture, I think he answered all of them before I even asked them. When I was preparing for today and for the lecture, I actually thought about starting with reading Adam's Bodnar paper published less than a year ago in an edited volume that he co-edited together with Professor von Bogdan, with Michał Bobek, and with Paul Sonnenwend. And of course, I think it was really interesting to see how his expectations, visions, and plans from September last year can be verified today in May 2024. But I would like to start with a quotation from Andras Jakab from the same volume. So, you know, this kind of sober, maybe slightly pessimistic approach about the possible transition. He mostly discusses possible Hungarian scenario, but then the last 3 pages he actually turns to Warsaw and thinks about the Polish example, and he exactly deals with something which was your last point today. So how to think about the rule of law as a process. So he points that, you know, polarization is one of the risk factors in this whole transition process. And this is something we are facing, I think, all around Europe. But then he says, erosion of the rule of law is not one-off accident, but a sign of a weak cultural immune system that is going to keep us on the edge. And he says, basically, erosion can happen again. It's not something that the business is done, is completed. We are on a safe side. So then I thought, let's try to compare the Polish and maybe Hungarian situation from the EU perspective, when we are kind of in a similar environment, legal environment. We are all, we have signed the European Convention on Human Rights. We are members of EU. So we are in a comparable situation, yet I have a feeling the situation might be completely different from when you think about the rule of law and the point at which the rule of law is now. So maybe let's start with Petra Bárd, professor at Radboud University in Nijmegen. Petra, could you start with trying to compare Warsaw and Budapest from the rule of law, from the trust, from the mutual trust perspective, trust that Adam already mentioned, and what is point of your expertise and your writings? Petra, please.
Is my mic on? Yes. Thank you very much for the question, Barbara, and also for the invitation. It's wonderful to have this CEU alumni reunion with an honorary alumna to talk about the rule of law and the restoration of the rule of law. And your question reminds me of a recent conference where I participated in Brussels. The whole thing happened under Chatham House rules. So I can't tell you who I had the conversation with, but I can say what he said. So I made a rather innocent point that legality, or a very strict understanding of legality, law is law, sometimes stands in the way of the restoration of the rule of law. I think it's rather uncontroversial in this group. But then there was a European official who very forcefully stood up and said, this is something that we can, on behalf of the EU institutions, not accept. We stand for legality because legality is part of the rule of law, and if anything happens in Poland that is not in line with legality, then we will start an infringement proceeding. And I was quite taken aback, and I argued that many times the Commission has been rather passive, and for once it would do some good not to start the infringement proceeding if we want Poland to return to the rule of law. And he said, it's none of my business. I stand here for legality. Okay, so that's the anecdote, and I don't think this is the position of the European Union as such, or the European Commission, because we do know that funds have been unfrozen, even on the basis of premises, so I don't think this is an official position. But it kind of illustrates the point that András Sajó very forcefully makes in a recent CEU DI working paper, actually. He talks about scholars and bureaucrats preaching from the high pedestals, I quote, of scholarly objectivity and neutrality, but in the end of the day, they are, again, I quote, apostles of appeasement. Okay, so I think that kind of summarizes the problem that we are having here. And I very much like the theory of John Morane's Building Back Better, when he brainstorms about how to restore the rule of law. He builds his theory an UN risk reduction approach, and he says that we have to slice off the problem. The problem is too huge, so we have to take 3 baskets. And the first basket are the uncontroversial things, he argues. There are some things that the government just shouldn't do. Stop slaps, right? Or stop identity politics with scapegoating of certain minorities. Stop harassing NGOs. Stop financing gongos. Stop corruption. Stop not implementing or condemning Court of Justice or ECA judgments. Now, there are also some uncontroversial issues where the government can be more proactive, but again, this is uncontroversial because you do not need the laws to be amended, and that could be a new foreign policy, that could be a health policy, that could, for example, be disclosing certain deals in the Hungarian context with China or Russia if they are not confidential and they can be disclosed and they are not classified, or join the European Public Prosecutor's Office. These are rather uncontroversial things from a legal perspective. And then there are baskets 2 and 3, and here you have to make some choices. So in an ideal world, of course, the whole system would be reformed and reformed for the better, even better than in pre-2015 times. But you have to make some selections. And here, Minister Bodnar is talking about politicians not being avengers, right? Not being superheroes in a way. So there are limited resources, there is limited political capital, there are some capacity restraints. So some issues are very frustrated, not to be solved, but you have to make this decision of not touching them. And then you have to make the selection, what is an absolute must? The National Council of the Judiciary in the Polish context, the Prosecutor's General's Office to be separated from the Minister of Justice Court Presidents, and so on and so forth. And here I see some guiding principles for the divisions, what comes into the second and what comes into the third basket. And here are the guiding principles. First, I think it's very country-specific, Barbara, and that kind of answers your question. I think it's a whole different question whether Adam now has an issue with the president of the country vetoing the laws, or whether you have a problem with the 2/3 majority laws. With all due respect, right? One possibility would be to prepare the laws, and once you have a new president, the next day promulgate them and sign them into laws, to sign the bills into laws. However, if you have a 2/3 majority, that's a big question whether you have the time and you can govern the country for 4 years and then perhaps have a 2/3 majority, which is highly unlikely for the second term unless you bend the laws, but the very idea is not to bend the laws but to restore the rule of law. And then what is the health status of the judiciary? Adam, if I understand you correctly, you have a very divided judiciary in Poland. The situation is very different with regard to Hungary. So the question is whether there is a bunch of judges that you can rely on when restoring the rule of law. And then the question is what you think about the governability of the country. And this is where we had this huge legal debate initiated by Professor Zoltán Fleck, who was the head of the main opposition candidate during the previous national parliament elections. And actually he's sitting in the room, so we have a very distinguished audience today if I look at the room. So he initiated this debate, and I think some scholars believed that you cannot govern the country with the existing laws, especially with the fundamental law, or they had some moral objections like you shouldn't govern the country with the fundamental law, which is the Hungarian constitution, which was accepted without the overall support of the people, or whether you can. And then there was also this difference between the strict understanding of legality or whether you can, under certain circumstances, rewrite certain laws. And this middle way seems to be the most promising one or forward-looking one. Of course, you cannot come up with extreme examples, and actually Viktor Kazai is also sitting in the room if you're interested, who clustered these several various Hungarian approaches towards rule of law restoration. But this middle way found a way very much in, or the greatest support perhaps, where you have to avoid, first of all, chaos, a legal chaos. You should avoid setting the way for a wrong precedent where every new government selects its own judiciary. And you have to avoid violence, which was also invoked by Professor Jakab, mentioned by Professor Grabowska. So with these having in mind, there is a legal track that can be followed. And probably this middle way with regard to the judiciary is, for example, getting rid of court presidents. So Dimitri and I, we have long argued that with a judiciary where the apex court judges, court presidents are captured, you cannot have a system where some judges are still independent. This is what the Court of Justice of the EU requires member states to do. So for example, when they are cooperating in the criminal sphere, to check whether one of the Hungarian judges or Polish judges is still independent in a hostile system. Now, we forcefully argue that this is not the case. Once the apex courts are captured, the whole system will be captured because it's them who have competence to say what case is system relevant and what will be decided in line of the rule of law and what will not. But the good news is that it's not true vice versa. If you want to restore judicial independence, you don't have to get rid of all the judges. It's sufficient to get rid of those court presidents or apex court justices. And there are some good suggestions, I think, in the literature and less promising ones. For example, Amin von Bogdandi and Dr. Speaker, they talk about criminal responsibility even of judges who apply laws in violation of EU law. I don't know whether that would fly or not. There are some other more promising approaches, such as relying on European Union law or ECHR law, because the ECHR already did the job for Minister Bodnar and for Hungary, in case there would be a return to the rule of law, there would be appetite for it, to say that sometimes it's okay to remove judges if they were irregularly appointed, and sometimes this is the way to be in line with the rule of law. Now, and with the remaining judges, you have to make sure that they interpret the law properly, and whenever they have to depart from the national law and give room to supranational law, let's say European Union law, it's made very clearly. There is oversight. It's temporary to depart from the law of the day. And that the judges, you can win the hearts of the judges because they tend to be trained in legality. They have to apply the law that is in force. So you can rely, according to Shayo's not so bad law theory, on already existing legal methods of interpretation, such as what was the legislative intent, reasonableness, or proportionality, in order to come up with interpretations that are in favor of restoring the rule of law. So my conclusion is that you cannot unscramble the eggs, but you can remove the broken shells in a legal way. Thank you.
Thank you, Petra. You mentioned Strasbourg, and I think this also Adam Bodnar mentioned this point as an important point of reference in future thinking about transition, but also in assessing the stage or the degree of the rule of law backsliding. And this is kind of the main point of reference also for the rule of law clinic, since in fact third-party interventions are not allowed per se. In Luxembourg, Strasbourg is a way more interesting place to actually defend and argue rule of law from the academic perspective. And a couple of months ago, I presented my research about the role of CSOs before the Court of Human Rights in those Polish, rule of law related cases. And one of the outcomes was that basically there was no academic involvement in those cases. The only exception, the only shining star, there was, the great Laurent Pech, who presented amicus curiae brief together with Lawyers for Lawyers association, but that was it. Like, there was no more academics involved in it. But then one of the points made by the audience here, Dr. Grabowska, you're absolutely wrong. There is Ghent Human Rights Center. This was basically the comment made by one of the scholars there who was also dealing with ECHR, and apparently this is absolutely true. We have together with us Eva Brem, the head of Human Rights Center at Ghent University, who is exactly this role model, how to link the academic research knowledge with making it work in practice, to make this human rights be also a practical concept. So Eva Brems, could you please describe or kind of show us a little bit of your work, in a sense, what is this dynamics between doing the research and applying in it practice, for instance, before the European Court of Human Rights?
Well, thank you, Barbara. That's a really nice compliment. I'm not sure it's fully deserved, but let me first congratulate you on building this clinic and also the sponsors of it, because you're right, there is a need for it, and there's an amazing relevance for research centers, academic centers in legal scholarship to be doing this impact-oriented law. I often kind of make the comparison with the faculty of medicine, I mean, imagine our colleagues in medicine would stop at studying how cancer works, how interesting, let's write a paper about it. And no, instead you want them to go further and know how to prevent cancer, how to cure cancer. And they go a lot further, because most universities have university hospitals in which immediately these new insights into how you prevent and cure cancer are applied to real patients. And typically these become the hospitals where other hospitals transfer their most complicated cases. That is self-evidence in that field. Now, law, like medicine, is a science that aspires not just to study its subject, but to change it. It is quite common for lawyers to not just analyze legal problems, but to propose solutions to these problems. In a way, then, it is surprising that we don't have the full equivalent of a university hospital in every law faculty. But we do have a clinical movement which has been big in some parts of the world for decades, but which really in continental Europe is just small, and in many places also very much under-resourced and relying on voluntarism. So I think what's amazing is that you will have this systematic focus on bringing legal expertise to bear on rule of law related issues. Indeed, like I said, we at Ghent University, we are one of these many centers that, relying on voluntarism, have tried to make our expertise have an impact in the real world. And we do this with master students, and we also do this with PhD students and with young researchers in multiple formats. But a lot of our work indeed engages with the European Court of Human Rights, and it is great that they actually have this ready-made format of the third-party intervention that is open to states, to civil society organizations, but also to academics and academic centers, where you can, as a friend of the court, directly bring your research to the body you want to impact upon. So that's a way to intervene in a pending procedure. How do we do that? Yeah, we bring data, we bring factual information, we bring comparative materials, but we also rely on our knowledge of the case law of the court to propose ways of reasoning for the court. In addition to that, actually, we are also engaging with the later stage of the proceedings, after a judgment of the European Court of Human Rights has been issued. There's the issue of implementation, enforcement, and there is also a possibility to intervene before the Committee of Ministers that is supervising the implementation process. And so we've recently started doing that too. Also, because what they receive is a report from the state saying, yeah, we'll do this and this and this, and that will be okay. And it is very useful to have another voice, a neutral voice, saying, well, actually, if you see the situation on the ground, a bit more may be needed than what the government is proposing here. So we find this extremely rewarding work. I'll maybe just give one example, just to show that rule of law challenges appear also in countries such as ours, Belgium, that maybe are not high on the list for people thinking about challenges on the rule of law. There has been, under our current Belgian government, a refusal by the government to comply with their legal obligations to offer accommodation and assistance to asylum seekers. And in particular, with regard to male asylum seekers traveling alone. So they say, yeah, okay, we can maybe deal with the women and the children, but not the men. So this created a huge humanitarian crisis in the streets of Brussels, people trying to survive there and suffering. Now, these people have been supported by attorneys. They have gone to court. There have been hundreds of court orders obliging the government to offer accommodation and assistance. There has even been case law of the highest court, even a ruling of the European Court of Human Rights. The government does not comply. So this turns a humanitarian crisis into a rule of law crisis. Systemic refusal to comply with court orders, and being proud of it, announcing it in the media like, yeah, no, that we're not going to do this, this compliance, which has us worried, which has our National Human Rights Institution worried, our bar associations, etc. So what we try to do from our position as academics, do our little bit in the upholding the rule of law, is trying to intervene in the next European Court of Human Rights cases with the arguments, with the facts, to emphasize the urgency in the eyes of the court, and also intervene, as I said, at the other end in the process before the Committee of Ministers. So I guess the bottom line is, I mean, rule of law, we talk, of course, about courts. We talk about courts and independence of judiciary, etc. But the protection of the rule of law is really the work of a host of actors, including all those actors typically considered human rights defenders, civil society organizations, journalists, attorneys, etc. But I think we should count academics among those actors who can play a role. Thanks.
Thank you. Now trying to refer to linking your presentation and Petra's. If you remember 2018 and the Selmer case, LLM, when this kind of test of trust is being introduced by the Court of Justice, this is the moment when actually the domestic courts, like migration court, criminal court, became also rule of law actors, and it was clearly said by the Court of Justice, despite the fact the Court of Justice decided just to leave the job to be done exactly by domestic actors. And then, of course, the role of professional lawyers also is one of the major one. If you think why so many preliminary references were issued by the Polish courts, probably the professional representatives of the parties was one of the issue. But let's try to back again to the EU and the role of the EU can play in this transition process, bearing in mind that it's not just about courts. I mean, right? courts. We listened, like we had this 30 minutes lecture, how complicated the issue of judiciary is. But outside the judiciary context, there's also the whole human rights protection system, which has to be somehow also, let's say, refreshed, bearing in mind that the whole human rights systems, they need effective legal protection. So without effective independent courts, no human rights protection system will be feasible. So Dimitri, let's think about the EU and possible options and role of the EU in this process. Bearing in mind, if you think about those human rights violations that may appear under the rule of backsliding, and Adam Bodnar mentioned Pegasus spyware being abused, but there are other fields. I know migration, when this is also a topic for the EU to think about as a rule of law issue.
This is a superbly important question. I applaud your efforts. It's really an incredibly difficult task to be at the front line and to let the whole world learn from what you are doing, basically. So my first question, just to start, is: do you think the European Union can learn from what you are doing? Not in terms of bringing the member state back into the ambit of compliance, but in terms of also thinking about the EU and the EU institutions differently. And here I want to move on beyond what probably Barbara hinted at non-compliance with European Court of Justice judgments, the CHR judgments, probably at the eastern border of Poland. There are still guys in the forest, etc. And this is something that you could stop. But in terms of the role that the EU itself plays in terms of establishing the whole landscape of the rule of law. And here I will give an Italian example. Corte di Cassazione several weeks ago sent a distinguished gentleman to jail for 8 years. It was a captain of a small vessel who saved a number of people from the sea, a number of African people from the sea who were trying to reach Europe, but they failed. And instead of sailing towards Italy, and Italy puts all kinds of obstacles on the way of such saving captains who are saving, he sailed towards Libya. And sailing towards Libya is a violation of international law, European law, and Italian law, including Italian criminal law. So he offloaded the guys in Libya, and he committed a crime. He didn't abide by non-refoulement. He potentially exposed them to torture, to inhuman and degrading treatment, and he will be serving a long sentence in jail for that. If we look at what the European Union is doing in this field, the European Union is arming the Libyan guys on the other side of the sea, providing them with drone intelligence, and investing now up to 900 million a year into Frontex, the EU agency that is designed to achieve essentially one thing: to make sure that Italian criminal law, Polish criminal law, Slovak criminal law, actually all the criminal law of all the member states, international law and the CHR law, are violated. And here I come to my main question, and this is where the EU could probably learn from Poland and restoring the rule of law. The EU rule of law idea now seems to be based on what I call supremacy rule of law, actually together with Laurent Pech at times, which is we all should view the substance of what the rule of law is about through the procedural prism of absolute primacy of what the EU institutions and the EU courts have to say. And to my mind, this is a very dangerous development, because Italy, within its own sphere of competence, which is highly limited, the EU is more and more powerful, can actually enforce the standards which the European Union is very often designed to undermine. And here I would laugh together with, I think, Petra at von Bogdan's proposal to send judges at the national level to jail who don't comply with EU law. Because very often, we need to face it, we need to be honest about it, compliance with the EU law, sometimes it's criminal. And my Italian example, I think, is very clear on this. So here we come to dialogue, and this is where Poland will lead the way. Dialogue between national courts and supranational courts, when it's honestly conducted in a substantive fashion, is the only way to establish the rule of law, it seems to me. And this is what I have been trying to argue for many years by now in the context of the European legal space. So we need to prevent the European Court of Justice from behaving like the illegitimate Polish Constitutional Tribunal, saying we are sovereign, full stop, and there are no arguments that anyone can bring against us. So the clinic has started work in this direction. In fact, the two first interventions we brought were drafted by Alexandra Tsipifanova, one of our first fellows, and concerned the Latvian situation, the situation at the Latvian-Belarus border, where plenty of people were tortured, thrown back into the frozen forest at -20, and then eventually repatriated to Iraq. She went to Iraqi Kurdistan. She learned some Kurdish to speak with those people. And what we are uncovering is really a systemic and horrendous system of mass human rights violations. So let's try to learn from Poland, and I'm wondering what Minister Bodnar can advise to the European Union in order to make sure that the European Union doesn't copy the Tribunal Konstytucyjny under so-called Judge Przylepska, or whatever the name was, and comes up with a substantive understanding of the rule of law, which is based on the dialogue and full compliance with international law, ECHR values, and the values of Article 2, what our union is built to defend and to promote.
As a follow-up to your intervention, Dimitri, you might have heard that Court of Justice decided in December last year that one of the newly established chamber of the Supreme Court in Poland is not a court established by law, and by that is not entitled to issue preliminary reference to the Court of Justice. So it's not entitled to discuss rule of law issues. Then that was one of the judicial independence case. It's not entitled to that. That was as a result, they reached this conclusion because they also tried to read the Strasbourg Court case law exactly dealing with judicial independence. And I think this relation between Strasbourg and Luxembourg is something that is really worth watching even outside the Polish context. However, this issue is a huge development compared with the previous decision from Getin Nobel Bank, where the Court of Justice had no problem with discussing the rule of law issue and judicial independence with one of those judges appointed to the Supreme Court in a kind of very legally doubtful way. But now moving to Adam Bodnar, and also starting with the paper published in the edited volume, you said, and I quote, "In 2023, Poland is not fulfilling criteria established in Article 49 TEU as interpreted in the light of Article 2." End of quote. As we know, already since December last year, quite a lot happened when it comes to the position of Poland in terms of rule of law, how it is being debated. I mean, the idea that rule of law is about dialogue is one of those issues. How do you think? What are the main changes that actually happened in perceiving the rule of law by the EU institutions, by EU actors? I mean, before this lecture, I received a couple of exactly these questions. What has changed? So I don't want to ask to summary your lecture, but basically, if you could point what has changed in terms of perceiving a Polish rule of law in the EU.
Thank you very much for those comments, questions. Please know that I'm not a scholar, okay? I'm not here as a scholar, okay? I'm a politician, okay? And it is a clear choice by me regarding also some issues and the way I argue them. And I'm also, which is quite difficult for me even to say, that I'm not a human rights defender any longer, okay? I may serve as a politician in order to protect rights, but Marta Pardawi is here human rights defender, okay? Not me any longer, okay? It was my decision made. In fact, after some discussions with Marta Pardawi, by the way, we had some long trip coming back from what was that? John Moraine's inaugural lecture and there was a ship hall jam traffic at that time, and we had long hours talking about some, let's say, life choices. Okay, but coming back to what has happened, I would like to start by Petra made such a statement which is a little bit about this. She said that EU money has been unfrozen on the basis of promises. It was not like that, to be honest. I remember that for me, one of the major tasks after 13th December was to basically do everything what is possible in order to unfrozen EU funds. Because we had to fulfill judicial milestones. And what Commission expected, they were pretty certain that we are not able to pass any legislation because of Mr. President. But they wanted to achieve, let's say, two major objectives. One is EU money is safe, and in order to do it, we joined EPPO, and it was on paper. It was not a promise that we are going to join, but we've submitted proper declaration. There was a hearing in one chamber of the parliament, the second chamber of the parliament. There was a visit of Laura Kövesi. There were some negotiations going on with the Commission, blah, blah, blah. And then there was a decision on 29th February this year of joining EPPO. And it was a symbol that we are going to limit our scope of sovereignty regarding the operation of the prosecution office, and that it means EU money is safer than it was. And right now we are in the second phase of selecting those European prosecutors, delegated European prosecutors, changing some, some detailed issues in the Code of Criminal Procedure. But basically it was that, okay? It was a very important symbolic moment. Second idea what Commission wanted is whether Polish judges are safe in making preliminary questions, whether they are safe in using EU law. So that's why I have started this practice of appointing those ad hoc commissionary judges, ad hoc disciplinary judges, in order to kind of stop this policy of reprisals against judges. So they can be right now safe that that with this administration, judges would be able just to adjudicate cases as they are. But I think what was additionally important is a little bit like the climate that has changed. Like, for example, you would never meet me next to the prosecutor standing in front of cameras saying, we'll indict this and this guy, okay? You will never find me criticizing any judge for the content of the judgment he did. When I hear about those, let's say, Armin von Bogdandy was mentioned, to be honest, I was quite skeptical when he mentioned this idea that judges should be criminalized for using EU law. But there are some situations where I can see some potential for criminal responsibility of judges. Please note there were some situations when there were existing judgments of the Court of Justice or the European Court of Human Rights, and there were Polish court presidents that were refusing to implement those judgments. So that could be the situation where you can potentially think about using this. But still, even if I would, being a minister, tell about it, I will always say, you have to do it in accordance with a proper procedure, rule of law based, you have to leave judicial immunity, and so on. I would never go into any, let's say, revolutionary type. There was a mention about those baskets, use of violence, okay? I remember statements by some really serious people, Chatham House rules, not mentioning who, like, maybe we should do something else with the National Council of Judiciary. Maybe there should be a police that enters the National Council of Judiciary and stops the operation, okay? And I said, come on, yes, but is it really like the rule of law-based solution? No, you have to do it in accordance with procedures, even if it may take longer period of time, even if in meantime you will have to pay some, compromise costs here. the question was about what the EU may learn. I think that for EU, it is also like a new situation, okay? I think for the EU, even, you know, this, there was, you know, some people consider this as a controversial thing, this Article 7, lifting of Article 7 procedure, okay? But I think Vera Jourova explained pretty clearly that Article 7 is used then when it is a clear risk of deterioration of the rule of law. It is a political instrument. If there is a government that says, we are doing our best to repair the country, we are changing our positions before the Court of Justice, we are making some actions, there are some pieces of legislation submitted, how can we say that it is still clear risk if they are going in a certain direction and they are giving like a huge political promise to this by this action plan, and they are not just promising, but they are just doing things in accordance with those with this promise. So what EU is learning, how to use all those procedures, to be honest. You know, conditionality is still something very, very new. You know, conditionality has 2 years in operation. I remember, you know, just to understand us how conditionality is new. I remember 2017, my colleague Maciej Taborowski organized a conference, in fact, together with Armin, at the Warsaw University, and there was a speech by one colleague, Justyna Łacny. It was October 2017, and she said, you know, she made a paper saying like this: there might be a moment in the EU law development that money is blocked because of the violation of the rule of law standards. And I remember that in the end of 2017, it sounded like a science fiction, okay? Right now, we are completely in a different moment. But I think right now, I wouldn't say that what EU Commission may learn. I think they are just observing. They would just react. I can imagine, you know, that this rule of law reporting would be much more intensive. Please note that even if the recovery money has been unblocked, I can imagine that maybe at certain points, certain tranches could be verified from the point of view of whether we are really going forward in this direction. I think this whole jurisprudence of the Court of Justice is important from the accession for the accession countries. And maybe I will say just one word responding to what Dmitry said. You know, for us, I would say that without the Commission and without the Court of Justice, we would not regain democracy. You know, I would always defend legacy of Kuhn Lennartz and what he did for the rule of law, and maybe I can imagine that it may go a little bit into this kind of a federalization direction, but without it, all those judgments and all those actions by the Commission, the litigation by Polish judges before the Court of Justice, it has delayed the process of political changes. And that's why we gained this momentum for the political choice, for the new political choice. So it is quite difficult for me to be in this, let's say, intellectual position right now to see some kind of threats in the way how the Court of Justice operates. You know, of course, the method of selection of judges should change. Of course, maybe some of the procedures should be more accessible. But in general, I think it is an important moment that in this very specific geopolitical situation, we shouldn't forget about geopolitics when thinking about also changes in Poland. The Court of Justice was important to protect European integration.
Thank you. I think now we can open the floor to the audience. If someone wishes to ask a question, I would like to first introduce yourself and then frame question. Please, Petra from Bodnar. Of course, you can ask question to each panelist, not just Mr. Bodnar. Here.
Thank you. I am Peter Molnár, and a former member of the Hungarian Parliament, and I would like to ask Adam about the story of what happened with the public media, also because in the other part of this auditorium a few weeks ago at a conference, one of the speakers said that it's sort of a bad example, and it's also a bad example that the European Commission is channeling money, notwithstanding what happened with the public media. Most of us who were there disagreed and thought that it was the right thing to do, but I would like to hear your assessment. Thank you.
Thank you. Would someone else ask a question? Jean.
Zsolt at the CEU. My question is also to Adam. There are many issues that you have to solve right now. But if you disregard a little bit the specific issues, and if you think about the general concept of self-governance of judges, do you think about this issue differently than you thought before entering into this process?
Thank you. Ben?
Ben Novak, with a research affiliate here at CEU. My question would be to Minister Bodnar. You mentioned here, I mean, we're kind of at the intersection of academia, activism, and politics here with the Rule of Law Clinic. And I thought it was really interesting that you mentioned how, you know, you're here as a politician. Don't hit me with these high-minded ideological blah blahs. But that's me paraphrasing, but you know, that presents a really profound kind of question for me. I mean, that transition from somebody coming from like a human rights defender world or an academic world stepping into the policymaker world is difficult enough under normal circumstances. The position you're in right now is not at all a normal circumstance. It's actually quite turbulent. And I wonder, what are some of the things that you have to sacrifice personally from that other place you come from to advance the job that you have right now? Thank you.
Thank you. Victor? I think we'll collect one more question, and then we're going to try to answer them, and then we're going to have a second round of questions. So please prepare more.
Thank you. Viktor Kazai, University of Brussels and the Civil Liberties Union for Europe. My question would be that if the reforms of the judiciary are accepted by the European Union and the Council of Europe without much criticism, I think that it's partly due to the fact that Poland has dozens of judgments declaring judges and sections of courts unlawfully appointed. But this is a quite unique situation. It didn't happen, or it doesn't happen in other countries, for example, in Hungary. So to what extent do you think that the Polish situation right now is unique, or it could be exported? What are the solutions that could be used in other countries in which there is no such jurisprudence of the European Court of Human Rights and the CGU on the lack of independence of apex courts?
Thank you. Somehow, most of the questions were directed to Mr. Bodnar, so please try to answer them, if you can. Yes, we do, but I think that will be the second session.
Okay.
Yeah.
Okay, a few questions. With respect to public media, please note that what we faced for previous couple of years is the total abuse of public media for political purposes. By total abuse, I don't mean some situations that you have some, let's say, way of interpretation of things, but public media became really like a source of hatred, propaganda, and slaps. You know, even myself, I was victim of one of the slaps of being the ombudsman still of the public media. A lot of hatred towards individual politicians, civil society activists, towards LGBT groups, towards judges. And at the same time, the situation of public media was such that they have been significantly cemented by virtue of different legislative measures and by virtue of different institutions. And the political choice has been made in the end of 2023. There was a little bit like the combination of, on the one hand, a resolution of the parliament, and on the other hand, the fact that public media are regulated by the code of companies, so by the private legislation, that basically the change has been achieved with the use of some procedures that are existing under the code of companies. And it created a certain controversy, but the end result of this whole situation, this controversy was, in my opinion, legitimized by this parliamentary resolution, quite straightforward, that gave a lot of, let's say, competence to and legitimacy to the Minister of Culture to do it. But it is interesting to see that the end result of this process is such that if I go right now, being the Minister of Justice, to public media, I'm scared to death of questions that could be asked to me, okay? Because journalists that are there are really powerful players, independent ones with high level of professionalism. So it was quite obvious that this whole attempt is not about, let's say, taking over for the benefit, but just to create like a real, normal public media. Dominika is a witness that when I go to Justyna Dobrosz-Oracz, for example, it's really painful exercise, okay? Because she's simply tough, you know. She's as any journalist should be. When it comes to the self-governance of judges, first of all, you know, at this stage, we must at least give back judiciary to judges, and because it has been taken over from judges for the last 8 years to the benefit of politicians. But the big question is, okay, but what to do next? If we go through this process, should judiciary be totally independent, including also the administrative supervision that should be in the hands of judges themselves, or whether there should be some element of the executive influence here? Because in Polish law, it is still that it is the Minister of Justice that is having administrative supervision over judiciary, and Polish judges would like to have either the supervision by the National Council of Judiciary or by the President of the Supreme Court. But then the question is, okay, if you even agree on this, okay, but are we mature enough as countries that we are also, that independent judiciary also in terms of administrative supervision would be accountable to citizens for how they are doing things. I don't mean the content of judgments, but basically the whole administration of justice. And I see here, I see this problem right now with the prosecution service, because Polish prosecutors, they all the time these days are talking about their independence. But I'm repeating them. But does it really mean that you have to be independent, which means non-accountable towards the public opinion? It means that you may hide, let's say, some weaknesses, some stupid decisions by just saying that you are just independent, or you are really also accountable at the same time. So how to put it in practice that you are also in a democratic state responding to some people's expectations, how you do your service to citizens. So basically, I would say that right now we are at the stage of, let's say, regaining judiciary for judges, but at a later stage we'll have to consider what should be whether judiciary should be self-governing and whether administrative supervision should be still somehow in the hands of executive power. What I had to sacrifice? I think I had to sacrifice freedom of speech in a way that I cannot say everything what I would say typically, okay? And I cannot say, first of all, because I'm bound by the group. I'm part of the bigger group in which I am. Second, I'm bound by restrictions that are imposed on the ministry in which I'm working. So I cannot openly criticize or openly say some things concerning Ministry of Interior or Ministry of Culture or some other ministry, because, you know, I have some other means to address my concern if I have those concerns, okay? I should use for this the cabinet, the Council of Ministers, and not journalists, not public media. And it is a big change. It is also a big change in my relationship with NGOs. you know, if there are some issues that are rather in the competence of some other ministries, I cannot take on myself the burden of those, let's say, complaints of those NGOs. It is a big change for me, because, you know, it means that you are a little bit cutting your links with your with civil society in which you were kind of growing up and in which you were part of. And final question by Victor concerning those unique judgments. I would say that it's not only a unique situation of Poland, because my feeling is that all those judgments would transfer into the body of case law and also into different recommendations and in different guidelines, either by the Venice Commission or by European Commission, especially when it comes to the candidate countries. So even if there would be no countries, even if some specific countries would not have similar examples or similar body of jurisprudence, I think Polish example and also this Polish transition would be used for other purposes. And I would like to give you just the example of the recent Venice Commission opinion concerning this National Council of Judiciary. I know that it was a very complicated opinion for them, because for example, you know, there is one part of this opinion in which they are arguing whether you may shorten the term of the constitutional organ, which is the National Council of Judiciary. And they basically argued that because of all those exceptional circumstances around the Polish judiciary, in some specific situation, you may do it. Before, as far as I understand, there was no opinion like this by the Venice Commission. So they try to find, because of this transition period, also for themselves kind of an answer to those delicate, sensitive questions that we are having. But later on, I can imagine that if there are some other countries, that kind of a body of case law and recommendations would be used for other purposes, for other countries.
We had one more question, two more questions, so let's start with you. And yeah, 3 questions, perfect. Do we have a mic? Yes, we do. Please don't.
Thank you. I also have a question to Mr. Minister. Although you have mentioned that you are not a human rights defender anymore, but I'm a human rights defender. No, I'm from the Hungarian Civil Liberties Union as like almost a colleague, and I'm wondering if you have like any tips or advice to human rights organizations working under Hungarian like current conditions, whether like you have any tips or advice for us. Thank you.
Thank you. We have a question from a gentleman here. Could you raise your hand? So, yeah. Great.
Thanks a lot. Sorry. Andras Csontos, an LLM student at Maastricht. A question for Professor Bárd, if I may, regarding your proposition that replacing the court presidents is sufficient to substantially restore the integrity of the judiciary. Doesn't that argument depend on the retention of quite considerable administrative powers on the part of the court presidents over the allocation of cases, the composition of benches, the timing of hearings, and so on? And if so, is that not in itself a potential problem for the rule of law, both in and of itself and when combined with the potential of today's opposition parties not necessarily being substantively committed to the rule of law? Thank you.
Thank you. Elena Baszewska.
Elena Baszewska, CEU Democracy Institute. So I'm very sorry, but my question also is to Minister Bodnar, but anyone else who feels like answering, I'll be happy with it. It's a very straightforward question. Do you envisage any rule of law crisis with regard to the Pact on Immigration and Asylum now, given the position of Poland and Polish not being very happy with it? I mean, I'm not very happy, but for different reasons probably. So I would like to hear what the position of Polish government on this is, particularly whether we can expect some new rule of law crisis in this respect. Thank you.
Thank you. Here, gentleman.
A much more simple question. Harsányi György from the Népszava Daily. Do you feel any support from the society to this procedure, restoring the rule of law? And don't you fear that this very strict legal approach is only increase the division in the society of Poland?
Thank you. So maybe, do we have any other questions? So maybe this time let's start with Petra to give some time to Mr. Bodnar to answer 10 more questions, please.
So I hope I understood the problem setting correctly. So I use judicial independence as an example of using John Moran's theory. So first, in the first bucket, you could say, stop harassing judges, stop using a smear campaign against judges in general. That can be done easily without legislative changes. And then, in the second step, the question is, what do you do? What do you do with all these judges that participated in deconstructing the rule of law actively? And here, well, I again can rely on previous scholarship, so it's not my invention, but András Jakab, for example, is saying that you don't have to worry too much about the judges in general, because most of them will be more than happy to actually be able to do their job after this transition and do what they took an oath on, namely to adjudicate properly, applying the laws properly, instead of being loyal soldiers to the government. And then there will be a second group of judges who will just be very pragmatic, so they want to make a career, and if the career is towards the rule of law, then this is what they will do. And yeah, there will be a small segment of justices who will try to stop rule of law restoration, but they will remain in the minority, so you don't have to worry too much about them. I mean, that's one approach. Again, this is why I was talking about the different approaches, different beliefs in the governability of the country with the existing scheme and how much changes you have to do. I don't see personally apex courts, especially, for example, the Supreme Court, the Curia in Hungary, having or leading the precedent with a leadership that we currently have that proactively contributed to understandings of the rule of law that are clearly in violation of the rule of law and clearly in violation of EU laws too. Adam Bodnar already talked about the disciplinary proceedings against judges and the importance of judges asking preliminary or sending preliminary references to the Court of Justice of the EU. Even though in the IS case initiated by Judge Vasvári, the Court of Justice of the EU expressly said that it's not okay to declare a preliminary reference legally invalid or illegal, even if it doesn't have any further legal consequences. And it's certainly not okay to start disciplinary proceedings against the judges just for sending the law. The actual judgment saying that it's okay to do that is still in force. It has never been withdrawn. It has never been overruled. And this was a deliberate choice by the leadership of the Supreme Court. So I personally don't see how you can rebuild the regime with these judges. The same goes to the precedent system. As long as you have this precedent system and they have the final say, it will be very difficult to do anything. Same goes for the Constitutional Court. And just remember that in a series of cases, Szalontai and others, the European Court of Human Rights actually acknowledged that this is a remedy to be exhausted, the Constitutional Court of Hungary. So how can you live with a captured constitutional court, which has to be exhausted, and by the way, which doesn't have a deadline to finish cases. So there are myriads of problems. Whereas if you replace these judges, you can say, yeah, we are still left with certain problematically appointed judges, perhaps it's some problematic judges in general, but then there is an appeal level which can remedy the problems. It's still substandard, but at least we are not facing all the problems from violence to legal chaos that the scholars have mentioned.
Thank you. I guess Dimitri could have comment on question about the pact from your perspective, not from the Polish government perspective, but I thought while Petra was speaking about actually the Court of Justice and this IS case, I mean, the part of the answer, the questions were answered, but part of them, if I remember correctly, were kind of set aside and left unanswered by the Court of Justice. So thinking about the role of the Court of Justice, that brought me actually to link it with Strasbourg system and the situation when the EU is still not part of the European Convention on the Human Rights. And I thought about a question to Eva Brems. You don't have to ask, I mean, you have to answer if you don't feel like, but do you think from your perspective as someone who's really active before Strasbourg, how do you think the EU accession to ECHR, how that would kind of improve the whole, the European human rights system, if you think as a kind of, in a general sense? I mean, so far I think we see it's almost impossible to happen, but maybe, I mean, I think that was one of the idea how EU could improve their rule of law position, since they are obliged to be part of the convention and the EU is not. I mean, you can take your time, and can we move to Mr. Bodnar, or no?
It's just that, yeah, I mean, we want a perfect system, so you want the EU to be a party and expect that it's going to have a huge impact, but in the end, it's a bit of speculation, I expect. You know, I've been teaching on rule of law protection this semester, and trying to be optimistic and give the students a sense of empowerment. But at the end of the semester, in informal contacts, it was clear that ultimately what I conveyed to them was a sense that what we have in place as supranational mechanisms is just minimal. It's not going to be saving the rule of law. And so, yes, let's do everything we can to strengthen it by all means and believe in it.
Yeah. Thank you. Okay. I think we can. Would you like to?
I just wanted to add one more question, if possible. I will not steal much time. And the question concerns the Polish presidency that is coming after the Hungarian one. What if this is already planned with some clarity? What would be the priorities in terms of the rule of law for Poland? That is the most significant example, precisely, of a steep learning curve in both directions. To share the knowledge with other member states and the EU.
That was like 5 questions.
Okay, thank you very much for those questions. Any tips, advices to human rights organizations? I think the result of elections in October 2023 was a combination of, on the one hand, civil society involvement and political movements that were kind of going together. But I think Polish civil society did a lot of good things. We have talked a lot about preliminary references that have been made by Polish judges. It would not happen without the involvement of really serious organizations. But when it comes to tips, I think investing a lot into the communication to so-called ordinary citizens, why those abstract values are important in their lives. But not only by just presenting some general examples, but by just reference to daily practice and daily abuses that happen. So what helped us is a little bit like the combination of this communication, what happens when the rule of law is violated, to women's rights, because the Polish Constitutional Court made this big political mistake of being involved into restricting access to abortion. So women's organizations had a powerful argument. The same with LGBT plus community. So somehow I remember that in the very beginning, let's say 2016, 17, 18, it was quite difficult to explain to people what is this rule of law about. But when it was going deeper and deeper, it was much easier from the communication point of view to connect like traditional protection of rights with rule of law value. And second thing, which I really recommend to anybody is going local. Is just promote all those values that seem to be abstract, like value of the constitution, rule of law, democracy, and so on, in any small town, in any small square, in any small city. Just getting out of the box, even going to a place where you will meet 5 persons, but still you believe that that it is important. For me, the action that has been made by my friend Robert Hojda, Tour de Konstytucja, so he visited more or less like 100 cities per year. It was extremely powerful exercise by him. In fact, answering that is one of those things I really miss, because being a politician, I cannot go with him because he's doing this in a very he's doing this in a political way by talking about political issues like constitution, but in non-party related manner, which was quite unique for Poland. That you may talk about serious cases, which are but not involving politicians at all into this. And even if there were some politicians who tried to approach him a little bit, he was always saying, sorry, you can be, but as an audience only, but not as somebody who is participating in that kind of event. So that kind of activities that require a completely different approach are in my opinion, important because they show that there is an alternative thinking about the state. There was a question concerning the Pact on Asylum and Migration. I think the official position of the government is that we have more than 1 million of refugees from Ukraine. They have a refugee status. We support them as much as we can. And that is why we think that we should have this restrictive approach towards asylum and migration pact. Second, and I think it should be mentioned, the situation on the Polish-Belarusian border is a completely different situation as it was in 2021. In my opinion, and I can say it, I also participate in some secret committees on defense and security. It is simply part of the hybrid war that is made by Russia and Belarus. Belarus is just as one of the instruments here when it comes to the destabilization of the situation at the border and the stabilization of the situation in the European Union. When it comes to the there was a question whether if there is what is the support of the civil society to the process of changes. I think there is still support. There is still this satisfaction that what we did in October 2023 was a great success of the Polish civil society. But at the same time, we are torn by some debates and some issues that are not resolved. So like women's rights issues and LGBT plus issues, we still do not have registered partnership. And there are some conflicts within the coalition partners regarding this. So in my opinion, irrespective of what happens in the rule of law issue, we should take care about guaranteeing those other protection of those other rights that were promised during elections. So I think that is, and right now we are in this specific moment because first there were local elections, now EP elections, and it was a little bit difficult to, on the one hand, to reform the country, and on the other hand, to get into those electoral disputes in the context of the local elections and the EP elections, and at the same time to touch upon those highly divisive ideological issues. For me, they are not divisive, but I mean within coalition partners they are divisive. But I think in the context of the legal changes, I think that there is like one thing that you should really deliver, and maybe I didn't mention, because I mentioned transparency, openness, and so on. But in my opinion, there is like one thing that is part of game here, is simply honesty. That whatever you do, you are not making it for your own purpose, for your own gain, for placing your people somewhere there, for creating some new schemes that is, let's say, replacing old people with the new people, but simply you are doing this all the time for the public benefit, for the public purpose, and also it applies to public expenditure. And I think that over the time people will see it and will appreciate it, and it would, let's say, limit the possibility of polarization. And final question by Dmitry. My idea, and I will do some things around it, and maybe it's not like the official part of the priorities during presidency, but for sure it has been acknowledged by the Prime Minister and in different talks, is that we should kind of show what is the role of the civil society in upholding and protecting rule of law in all the EU member states, and how shall we, as the EU, protect and support the EU civil society, the civil society, and in protecting this key EU value. So that's why for sure we'll observe how the SLAP directive is implemented. For sure we'll look into the process of funding for NGOs, whether this money is available and whether it could be really used for typical purposes. We'll support investigative journalism and protection of journalists against reprisals. We'll take care about freedom of academia. And I think, I remember last time when I was in Budapest, I was talking about, I had a big speech at the Polytechnic, at the freedom of academia here. Because otherwise, without the independent EU civil society that has the freedom to act and is supported properly in member states, will not be able to protect rule of law and polish. One more thing, the independence of bar association is extremely important. So basically, I would like to take care about all those elements where the EU law could be supported, enhanced, and the operation of the EU institutions could be better in order to make this connection between the civil society and the rule of law guarantees. Thank you.
I would like to thank you for the attendance. I think we have reached the human possibility to discuss rule of law for more than 2 hours. Thank you for attending the event. Thank you, panelists, for accepting our invitation. It was a true pleasure to be today with you and to be able to discuss rule of law being exactly the practical concept. Thank you, Mr. Bodnar, for accepting the invitation and deciding to spend your whole Monday in Budapest. I think it will be extremely interesting to see when the executive, not a human rights defender anymore, is a rule of law actor, and his work is going to be also part of the academic research. I would like to thank Olena Stetsenko, Judith Sarkacz, and Silvia Palgai, and anyone whom I ever emailed anything dealing with today's event. Thank you so much for your work and for your help. I think we can continue discussion at the nearest atrium where coffee and pogača will be served. Thank you so much.
Mm.